and I am the chair, at least for another meeting or so, at the end of the month, of the Hawaii Civil Rights Commission. And so I would, at this time, call the June 10th, 2025 meeting of the Hawaii Civil Rights Commission to order at, looks like 2:01. So we have some new commissioners that I'll be introducing, but I'm required under state statute to announce the names of all participating members. And so well, I'll start, as I've already introduced myself, as Dr. William Pewitt, and I'm the commissioner and the chair of the commission at the current time. And then we also have John, sorry, John Matsuoka, who is a commissioner, and he is present. And our two new people, I'd like to begin with Alfonso Braggs, who is interim commissioner. And perhaps you could say a few words. I noticed that on the HRC website where it says Meet the Commissioners, there's a nice bio and paragraph. So, but perhaps you'd like to say a few words by way of introduction.
Good afternoon, everyone. Alfonso Braggs here, and I'm extremely honored to begin this journey.
Excellent. Okay, that'll do. And then we have, Raymond Nichols. Raymond, you have the floor. Please say a few words, maybe, of introduction about yourself.
Yes, hi everyone. I'm excited and honored as well. Third-year law student, was no surprise excited about civil rights, and happy to be here and contributing.
Very good. Okay, well, welcome to both of you. And well, I won't be able to look forward too much because the next meeting is my last meeting, but I'm sure the commission and all of the members of the Civil Rights Commission and staff are very happy to welcome you, which gives us a lot fewer problems to deal with regarding quorum. So we do have quorum at this point, and we'd like to move along on the agenda to the next item, which is the approval of the April 15th minutes of the last commission meeting. So I don't know if it'd be easy for you to put that up on the screen. Maybe Sandy, you're the host. But they have been distributed and they've been posted online. And so the question is, are there any corrections to the April 15th, 2025 minutes of the Civil Rights Commission meeting? And if they're not going up, it's okay because they've been posted. So I'm just waiting for someone or anyone who may have a correction. So John, do you have a correction? You were there. I was there. I don't have any corrections.
No corrections. Move to approve.
No, a motion to approve is not required under Robert's rules. So, in fact, Robert's rules tells us that the only way you can properly deal with minutes is to offer a correction. And there being no correction, the minutes are approved as circulated. All right, that brings us to the executive director's report. So I didn't introduce the staff yet, but the executive director, Marcus Kawatachi, is here, and I call upon him at this point to and recognize him to give the executive director report.
Thank you, Chair. Just want to say up front, we are going to miss you, William.
Oh,
and your intimate knowledge of Robert's rules and every other rule that applies to our meetings. And I want to say, a very hearty welcome to our new interim commissioners, Alfonso, Ray. Very good to see you. So what I'm going to do now is I will share two reports. And let me pull them up. Oh boy, where is it? Um, 1 second, please.
Are you hosting? Do you have host?
Yes, but I'm having trouble finding my documents here. Okay, this is not working. 1 second, please. Let's see. You know what? I must have closed them out. Okay. Oh, I understand. Here we go. Okay. So share. No, that is not it. Here we go. So I do have two reports that I share at every meeting. I'll start with the caseload report, and I will have some additional explanation for our new commissioners. So this may take a little more time. What we have here is a snapshot of the cases within the Hawaii Civil Rights Commission's caseload, and this is as of end of business yesterday. So what I'm reporting on is open cases in investigation. So we have different stages of our complaints, from initial intake to filing of the complaint, investigation, and if a case goes forward, we talk about enforcement. And so these are cases within the investigation stage where there still needs to be additional work done before we can determine whether or not there's enough evidence to show a violation. And if there is enough evidence, we'll go forward again to the enforcement stage. So this is prior to enforcement. So what we're looking at here is, as of end of business yesterday, we had 370 cases within our investigative caseload. These are listed here by the year in which the case was filed. And we did have one for a long time that was filed in 2017. But as of this month, that is no longer in our investigative caseload. I'm happy to report that case has moved on to another stage. But you can see here that in terms of the age of cases, as you might imagine, there are, just a few cases that were filed in our oldest category of 2018, and then more in 2019, more in 2020, et cetera. Relatively few, but as you get to 2021 and further, that's the bulk of our caseload. And so, as you might know, to our new commissioners, we have complaints that we file, and the largest percentage are employment-related cases, but we also do have cases in housing discrimination, discrimination in places of public accommodation, and also access to state and state-funded services. And so these comprise, the 370 cases that you see here. And in terms of how long a case is in this particular phase, it really is case by case, whatever it takes to fully and fairly investigate the claims. So it may depend upon the complexity of the case, the number of allegations, the number of people involved. There could be issues with regard to getting compliance from the respondent or respondents to give us a response, or to have witnesses appear. So there's all kinds of factors that go into the life of a case. But again, what we need to do is to devote whatever time and energy we need to fully and fairly investigate every single case. So I'm going to scroll further down here. This category here at the top is changes from the last report. So again, that very stubborn case from 2017 has moved on to another phase. There were no changes in our 2018, 2019 file cases, but you can see that we have had cases resolved or concluded from 2021, 2020 and on. And so month to month, I do report on these changes. One thing I will say is that this is sort of a snapshot aggregate look at our caseload. Because of our statutory restrictions, I'm not able to talk about details of any open cases. So no identifying information. I might be able to talk just really in general terms, but we try to keep it as general as possible, because you as commissioners might actually be adjudicating these cases, down the line. And also, I mean, in terms of our statutory requirements, we just cannot strictly, cannot disclose case-related information to anyone, while the case is ongoing. Okay, and so going further down, this case aging section, I think is probably one of the most important bits of data that we report, because it talks about in terms of the relative age of cases where we are. And so we've broken it down, and we decided over the course of years to do it this way. And, if anyone has any suggestions of how we can, do better, we can certainly look at that. But we're looking at cases that are, 2 years old or older is one category. And then between 2 years and 18 months, between 18 months and 12 months, 12 months and 6 months, or 6 months or less. And so in terms of percentage, you can see here the percentage of our total caseload in this report, and then on the right side, what was the percentages from last report. So I've been reporting to our commissioners for quite some time about the age of our cases and things we need to work on. So the oldest category of 2 years or old, we're at 37.8% of our caseload momentarily. And that's high. That's too high. We've been really trying to get that down, and we've made concerted efforts to do that. We are working on getting fully staffed, getting our staff fully trained and tackling these cases. And so I will be reporting on that every month and keeping an eye particularly on that oldest category there. And then this next section is a breakdown by case stage or category. And so the first category we have is housing cases. I mentioned up front that employment cases are the most numerous types of cases we have, but then I think next is probably our housing cases. Right now, we have quite a few. It's normally not this high, but we have 96 active housing cases in our caseload. And you can see by age, the oldest are from 2021. And then further down, we have a category of non-housing cases. So it would be, again, employment, public accommodations, access to state or state-funded services. And then these are the stages that roughly in order of in reality, the life of a case. And so we have response monitoring. So when a case has been filed and we're waiting for either any sort of response, or a response has come in and it's not complete and we need to get more information. And so that's one category, is we're waiting for there to be a complete response from the respondent once a complaint's been filed. We also have a category, which is sort of a side category, of mediation. So we do have a process where our parties can engage in mediation, and if they succeed, they come to a settlement, close out the case. And so we presently have 54 cases within the mediation process. We then have the category of pending assignment. So these are cases where we've gotten a complete response. The case is not in mediation and it's waiting for assignment to an investigator to do what they need to do to complete the investigation. And then lastly, we have active investigation. So these are cases assigned to our investigators, and they are actively interviewing parties, gathering information, doing site visits, doing some research, whatever it takes to, again, come to a full and fair investigation and ultimately determine whether or not there's enough evidence to show a violation. Okay. Or I would say more precisely, enough evidence to go forward to the enforcement stage, at which time we would try to prove that the violation has occurred. Okay, so that's a lot of information. The way that my screen is, I'm not seeing everyone at the same time, but are there any questions or comments that I could field at this point before I move on? Okay, I'm not seeing any. So I'm going to keep going. There's just one category, it just went long, so it's on the next page, but subpoena enforcement, which is if there are any cases in which our attorneys are enforcing subpoenas that have been sent out, and that could be to have witnesses appear, it could be to have a respondent comply with a request, or other things that we would report in this space. But as of last report, there's not any subpoena enforcement going on at this time. Okay. This next page is our fiscal year comparison. So you can see the fiscal year running from the beginning of July to the following end of June. So going back all the way to fiscal year 2015 up until last year, fiscal year 2024. This doesn't change from month to month, but once we have a complete set of statistics for the fiscal year, and that's really when our annual report to the public has been released, then we would add these statistics down here. And so perhaps our new commissioners might take the time to take a look at this. Our reporting does go into our minutes for each meeting. But this fiscal year comparison, because it doesn't change, we don't put this in the notes every time, but I could send this to you. So this gives us, again, sort of a year-to-year cumulative view of what's been done during these past years. And I'm not going to go through in great detail here, but things such as the number of complaints that were filed, the number of investigations that were completed, number of settlements we had, et cetera, et cetera. And so, yeah, again, perhaps if people have questions, I can field them at the following meeting. But I'm going to move on to the last category here, which is the year-to-date statistics. So we're looking at within the course of a fiscal year. So again, starting at the beginning of July, and which would end at the end of June. So from the beginning of July to whatever the date in time is in the fiscal year. So it would be June 9th would be yesterday. We're looking at what's occurred during that time period and going back for 5 years. So I will talk about this because I think it does sort of explain some things about our process. PCQ stands for Pre-Complaint Questionnaire, and that's the first written piece of or form that's submitted that has a lot of information before a complaint's even filed. Okay, so that a lot of times is the initial thing that a person submits if they want to engage with our process. And so you can see the number of pre-complaint questionnaires that were received during this period going back for the past 5 years. And I've been reporting, quite consistently that when COVID hit, our numbers really dropped in terms of pre-complaint questionnaires received. And since, restrictions have lifted, we've gotten back to some sense of normalcy, they've been slowly increasing. And so you can see we're at 573, which does exceed, the past 5 years. So I think we're back to pre-COVID numbers of pre-complaint questionnaires received from the public. The next category here is intake decisions, and that means once we have a pre-complaint questionnaire or someone comes to us with a situation, we go through the process of intake and then determine whether or not we have the right type of information and enough information, and the person wants to proceed to a complaint. And so we make a decision whether or not there's going to be a complaint or not. And so that decision, reflects, a lot of times it's in keeping with the numbers of pre-complaint questionnaires received. And, as of this date, we have 525 of these intake decisions. The next category here is complaints filed. So if there is the right type of information and the person wants to proceed at intake, then we will file the complaint. And at that point, there's a formal legal document that says, complainant believes he or she has been discriminated against on the basis of XYZ against the respondent. And this is the formal document that we use to go forward and investigate. So as of this date, we have 167, as of yesterday's date, 167 complaints filed. Investigation closed is, I talked about the investigative stage of the process. So our investigators, again, do whatever it takes, interview parties, do site visits, request documents, do research and come to a recommendation, and at some point we determine whether or not there's enough evidence to show that enough evidence to justify going forward to show a violation. And so as of this time yesterday, we had 175 investigations closed. If we go through the enforcement process, next category is notice of cause. If we go through the enforcement process and we find that there's enough evidence to show a violation, we would issue what's called a notice of cause that gives legal notice to the parties that we are in the enforcement stage and that we do intend to, I guess you might call prosecute this case to show that there's been a violation. And so as of this time yesterday, we've had 12 notices of cause issued. And then finally, enforcement closure. And this could take many forms. It could be a settlement once there's been a notice of cause. It could be a case goes to a hearing. It could be that the parties settle on their own and withdraw. So as of this yesterday, we've had 4 enforcement closures. So these are all pretty good numbers. I think we've seen increases in some of these. There's a pretty dramatic, you can't tell by the sheer number, but a pretty good number of investigations closed since the last report. And so I think that trend is going to continue in the months to come. Okay, so lots of information, hopefully not too confusing. Any questions at this time before I move on to my second report? Okay, not seeing any. I'm going to, where is it? Hold on one sec. Okay. You folks see the mediation?
No, we
Oh,
see
you
a
don't?
Zoom. No,
Oh, man. Okay, hold on. What is going
there
on?
it is. It's up now. The mediation is up now.
Oh, you do see it? Okay, terrific. Okay, so this is the mediation program year to date. I normally start with this one, but I thought it made sense to give some context to this report. This is a much shorter report. I discussed that we have mediation as an option. So if the parties all agree, they can sort of temporarily exit the investigative stage and move to mediation, which is either conducted through community mediation centers or private mediators, or if with housing cases, we have our own in-house mediator who will mediate those cases. And so it's a way that the parties can, often early on in the process, they can come to an amicable solution and end up withdrawing the case, and we end it from there. And it's again voluntary. It's there's no negative in my mind to going through the process, because if it doesn't result in a settlement, it simply goes back to investigation. So this is the year-to-date statistics. And so the way that you would read this is the number first here. So we had 23 referrals last month, or from last report, and then we had 10 additional referrals since last report. So we have 33 as of this date. So a referral is a case is simply referred from investigation, typically, into the mediation process. So we had 10, which is actually quite a bit since last report, up to 33 for the year, fiscal year, that is. We had, I'm going to skip down, under dispositions, we had 1 settlement. And so 12 from the previous report, adding 1, we have 13 year to date. Previously, we've had 4 cases go through mediation, which did not result in an agreement. So 4 there. And so 13 settlements out of 17 total dispositions is a very, very high success rate of 76.5%, which that's actually pretty outstanding. And so looking at the types of claims that did settle. So, okay, so we've had 13 total settlements in mediation, and we look at the primary basis for the complaint. So each complaint has at least 1 basis of discrimination, so race, sex, color, disability, etc. We have one that's selected as a primary if there are more than 1 basis for complaint. And so in terms of the settlements, we've had 4 cases where the primary basis was race, 4 where the primary basis was retaliation, 3 for disability, 1 for age, and 1 for arrest and court record. And then looking at the overall numbers, again, 13 settlements, 11 of these were dual filed, which means that they were filed also with either the Equal Employment Opportunity Commission or the U.S. Department of Urban Development, depending on what type of case it is. And 2 of them were not, so those were state-only cases. And then of the 13 settlements, again, we have 4 of them were employment cases, 8 were housing cases, and 1 was a public accommodation case. And I mentioned before that mediation could take place either with the community mediation centers, private mediators, or our own commission mediator. And you can see in this chart here that our commission mediator has mediated the bulk of the cases this year so far. So 10 of them, 8 of which were successful settlements, so a stellar 80% success rate. The rest were through community mediation centers. So Mediation Center of the Pacific had 6 mediations, 4 of which settled. And Kuikahi Mediation Services in Hilo had 1 mediation which settled. And so we're nearing the end of our fiscal year. Numbers are a little lower than in past years, but the successful settlement rate is quite a bit higher than in previous years. So maybe that's a wash, I don't know. But anyway, any questions, comments from anyone? Okay, if none, I will stop sharing and hand it over to our chair.
Aloha, and thanks for a fantastic report. And even though it's my last meeting, I really enjoyed your explanations. So I hope they were helpful to, particularly to our new members of the commission. So the next, as you can see on the agenda, the next business that we will be taking up is the Chief Counsel's report. So at this time, I recognize Constance Yonashiro, who is Chief Counsel for the Civil Rights Commission.
Thank you, Chair, and welcome our new commissioners, Alfonso and Raymond. As background information for our new members and also guests that we have at this meeting, I just want to explain, the structure of the HCRC. So the Civil Rights Commission is separated into 2 separate and distinct sections. One is the enforcement section, which is headed by the Executive Director, Marcus Kawatachi, who they receive complaints of discrimination, investigate, and if appropriate, they will prosecute those on behalf of the state. And then we also have the adjudication section, which is headed by the commissioners, the 5, unpaid volunteer commissioners. So Marcus and the enforcement section acts somewhat similar to the prosecution's office, where they will take cases and take them through before a hearings examiner who will issue proposed findings of facts and conclusions of law, take evidence, and then have a recommended decision for the commission to review. And also the commission will review the record as a whole as well. At the end of the review, the commission will issue a final decision and order, which will be appealable to circuit court. So that's how our structure is made up of. And so, if there are investigators or enforcement attorneys, there's no ex parte communications with the individual commissioners, that we're pretty much separate on that. So onto my update. Oh, also, so my role as Chief Counsel is to advise the commission on any legal matters. If I am recused from a case, which I am in the case that you will be discussing in executive session, because I did spend 8 years as an enforcement attorney, then you will be advised by Deputy Attorney General. And in this case, we have Leanne Yamashiro from the Attorney General's office who will, take over those duties to go over the hearing examiner's findings of facts and conclusions law. So the first thing on the agenda for my report is an update on the proposed amendments. So this has been going on for quite a while. It's a pretty big undertaking. The Civil Rights Commission's authority and ability to enforce state law, it comes from both statute and admin rules. So our admin rules, they have the force and effect of law because of this very lengthy rulemaking process where we take public comments, we have public hearings and things like that. So I've been in my position for about 2 years now. My predecessor actually started on these amendments. So it's been over 2 years in the making, but it's on the governor's desk. We were told that he would sign off on these rules because we've completed, public comment period. We completed the public hearing, and all the notices. So we're at the very end. We just, need his signature. So we're hoping it will get done in the next, couple months. But we wanted to primarily update because we haven't updated our rules in, I believe it was about a decade. So we needed to update terms to be a little bit more consistent, account for technology like e-sign, things like that. And it just became where, if we were going to update one thing, we had to keep updating more things. It was, like that book, if you give a mouse a cookie, if you're going to update this, you might as well update that. So our amendments spanned 170 pages, which is also why review of our proposed amendments took a really long time. So at the next meeting that we have, I'd like to go a little bit more in depth with those rules. There's a little bit substantive changes, especially with in our sex discrimination and employment section, because we try to align that with the Federal Pregnant Workers Fairness Act. And also to eliminate binary and gendered terms, things like that. So, and one thing for the new commissioners and all the commissioners to think about is to avoid this massive, rulemaking every 10 years, it might be better to start thinking of where we would like to target different changes. And then it might be faster and easier to make those changes incrementally. So for instance, we have administrative rules on employment and housing, but we don't actually have any for public accommodations. And there's other things, that we might have a statute on that's not very clear on how we would enforce it. So, for instance, the Pay Transparency Act that was passed, I think a couple sessions ago, we might want to think about how we might want to make it more clear through administrative rules on enforcement section. So that just might be something that we might want to think about for rulemaking next time. Okay. So I think that's the update on the proposed administrative rules.
Okay. So you want, unless there's
I just-
questions, move on to the next thing, which is
Yeah. And I apologize. I caught a cold, so I hope I won't cough too much. Okay, so the next thing on the agenda is update on 2025 legislative session. So we had two bills that passed through the ledge and got to the governor's desk. SB 31 was regarding discriminatory restrictive covenants. It would have amended Hawaii Revised Statute Section 515-6. But on June 6th, the governor sent out a notice of intent to veto. So it goes back to status quo. And I just want to say that because we already have chapter 515-6, which says any provision in a real estate transaction that basically discriminates on a protected basis, race, sex, gender identity, sexual orientation, color, religion, etc., is void. So what SB 31 was trying to do was to create a mechanism to allow for removal of these restrictive covenants if somebody found that they existed. And I guess the governor's office believed it was a little bit too broad. So I'll just read what his intent to veto stated. Let's see. So his veto rationale was by enabling a person, including those without interest in the specified real property to record a statement that a real property's title includes a discriminatory or restrictive covenant. This bill provides a statutorily authorized mechanism for the circulation of disinformation. This disinformation has the potential to negatively affect the marketability of a property. Because the person who recorded the statement claiming a discriminatory restrictive covenant exists is waived of any liability, no recourse is available to those who suffer financial loss due to inaccurate claims concerning their property's type. So that was the veto rationale. So that's not how I would have interpreted the bill. We supported, as background information, we supported this bill. We gave testimony on it. It's interesting that they use the word disinformation because a person has to file notice, of this if they feel like there is a discriminatory restrictive covenant in this real estate transaction. They would have to do it so in good faith, So there were there was language in the bill that tried to prevent just random disinformation, but so that's where that is. Another bill that we were tracking was Senate Bill 116, which is discriminatory reporting to law enforcement, and it would amend our statute HRS section 368. So, and that one is still on the governor's desk. We don't know the status, but we have not got an intent to veto on that one. So I'll update as we hear back.
Thank you. And the next item is update on docketed cases.
All right. So, so like I mentioned, we have two separate sections. So when the executive director finds reasonable cause exists, that discrimination happens, then they docket the case with the adjudications office. So currently we have 3 docketed cases. They're all housing cases. The first one is Marcus Kawatachi, executive director, on behalf of the complaint filed by Knipe versus Gary Sumner et al. This case is going to be discussed in executive session. It already finished the hearing. The hearings examiner submitted findings of facts, conclusions of law. I am recused from this case because of my time spent as an enforcement attorney, and Commissioner Arsima Muller, who isn't present today, she's also recused from this case. The second case we have docketed is Kawatachi on behalf of a complaint filed by Sheldon versus Fiona Massa-Oy. It's also a housing case. Arsima also will be recused or excused from this one as well. Hearing was held on April 28th. The hearings examiner submitted his findings of facts and conclusions of law on May 30th. It's still in process because the parties have the option to file exceptions and also to request oral arguments in front of the commission if they want to, but we haven't gotten that yet. So I'll keep you updated on that as well. And finally, we have a third docketed case. It was docketed on May 5th, and the contested case hearing is scheduled for October 6th. So by our rules, we have to have a contested case hearing within 6 months of docketing the case with adjudications. So it's a pretty short timeline, but if any party requests an extension of time to hold the hearing, they would have to come, request the commission grant an extension of time to hold the hearing.
Okay, I'm sorry, does that conclude our, was there a third one? No, we're done. You did the third.
Yeah.
Okay, sorry. All right. Well, thank you. And at this point, I see we have quite a number of people who are here. And so I'm assuming there may be people who are present who wish to give public testimony. So far as I know, there's nothing been submitted in writing. Is that correct?
Correct. We haven't received any.
All right. So nevertheless, at this point, people who are present have the opportunity to speak to us about the agenda items, and particularly that would be under Agenda 6, and the one you talked about before, the docketed case number 1, which is Knight versus Sumner, as trustee of the Holualoa Residence Trust. So, is there any member of the public who wishes to speak at this point? And again, it has to be on an agenda item, so that would pretty much be the one that's listed on the agenda here. Do I see anyone who wishes to speak? And so far, I don't. So that being the case, we will move to agenda item number 6, which is planned to be an executive session or executive meeting. In order to go into executive meeting, the commissioners, by 2/3 vote at a meeting where there is quorum, must vote to go into executive session. That would mean that of the 4 commissioners who are here, we will need 3 to be able to go into executive session, if I have my numbers right, because this is based on the members to which you are entitled under the Sunshine Law, and the commission is entitled to 5, so 2/3 would be 3. So the question to begin with is, shall the commission move into executive session to consider the attorney-client discussion on contested case hearing for Marcus Kawatachi, Executive Director, on behalf of the complaint filed by Junko Knight and Gary Sumner, okay, as trustee of the Holualoa Residence Trust. So, and I can put that question to you. And at this point, I would ask, are there any objections from the commissioners to going into this? So, commissioners, is there any objection to going into executive session?
No.
None.
So hearing no objection, then we will go into executive session, and we are required after executive session, and we return to open session to have a report on the discussions and any business that was enacted. So, but for right now, and I'm going to ask assistance of Sandy Yoshimura I think we're going to go into, what do they call this, a chat room, or in order to do this, but to go into executive session, only the commissioners can be present. So how are we going to do this? Last time we went into executive session, there was a room, and we were all able to move into it. Has that been organized?
I think Sandy created a breakout room.
Breakout, that's the term I was using, breakout room. So, but Randy, are you here? Can you let us know if there's a breakout room? Because we have to choose it and go into it. So I have somebody who said their audio is not working. Okay. But that's not somebody who's going to be in the executive session anyway, so. And
Let me take a stroll over and see what's happening.
yes, please do. In the meantime, the commission will stand at ease.
Were you able to?
No, there's no, usually we get a note that, if the commissioners can click on a button that will take
Right.
us into a breakout room,
Correct.
but I don't
I
see.
have 7 people in there right now.
Oh,
So there we go.
now I got it. Okay.
Okay.
Okay, I'm just going to turn off my camera and audio for now.
Yeah, I will as well. Just keep an eye on things. Okay. See you, Connie.
Okay. Do we have all of our commissioners back? They're looking to see. John's here. Ray's here. Alfonso's here. Very good. All right, so the executive session is expired or concluded, and we now can reconvene in open session. And at this time, the chair will put the question before the commissioners for a vote. And the question is that to accept and adopt the hearing examiner's findings of fact, conclusions of law, and recommended order, with the exception under recommended orders of C3, under equitable relief and letter of apology. So,
Dr. Wood, could you also just briefly say that the commission discussed the findings of fact and the order and then put it to the vote?
okay, so I should have started with the commissioners discussed the findings of fact and the other pertinent documents that were distributed to the commissioners. And
As presented by the Deputy Attorney General.
as presented by the Deputy Attorney General. All right. And therefore, is now is presenting the question, and the question is, shall the Hawaii Civil Rights Commission adopt the hearing officer's findings of fact, conclusions of law, and recommended order, with the exception under C, equitable relief number 3, which deals with the apology. So, and we can't do a voice vote, so this has to be a roll call vote, I'm assuming, unless I could ask, is there any objection? Or would you prefer that I have a full roll call vote?
A roll call vote would be
All
great.
right, very good. Okay, so with that question in mind, how do you vote? John Matsuoka, Commissioner.
Aye.
Okay, and Ray Nichols
Aye.
and Alfonso Braggs.
Aye.
And I, as the chair, also vote aye in favor of this motion, and therefore it is adopted by the commission without objection. So unless there is any other business, oh, there's some announcements. So I see on the agenda that we have an announcement that the next meeting is an in-person meeting on June 17th. I believe it's at 1 instead of 3. And this is going to be a farewell paina for your chair, which would be me, Dr. Pewitt. And I thank you if you're able to attend that. There has been an agenda that's posted, and if you haven't seen it, you may want to go to the Civil Rights Commission page where they have all the agendas and minutes, and you can, at that point, of course, follow the instructions in the bouncing ball. Are there any other announcements?
No.
Okay, other than that, it's on the agenda. If you need auxiliary aid, service, or other accommodation due to a disability, contact Executive Director Marcus Kawatachi or the Civil Rights Commission email that's on the agenda. Hearing no further announcements, the meeting is adjourned.
All right. Thank you all.
Thank you.
See you next week.
Aloha.
3:25, right? So